Bismillahirrahmanirrahim. Dear fellows, today I am going to deliver lecture number 8 on Companies Act 2017. In this lecture, I discuss all the dimensions that are required to be followed to convert unlimited company into a limited company. But before going into this deep discussion, we should need to understand unlimited company and a limited company. So the Cambridge Dictionary provides unlimited company, a company whose shareholders will have to use their money or property to pay the company debts if it fails financially. So this thing is expressly classified in the definition of unlimited company, that the shareholders will have to use their money or property for discharging the company's liability. So under this scope, we give the title of unlimited company to any company. Now, what is limited company? It is also expressly provided in Cambridge Dictionary, a company whose owners only have to pay part of the money they owe if the company fails financially. So it creates the limited liability of the shareholders of the company to the extent of their shareholding in the company. So here we have distinguish unlimited company and a limited company. Now we look into the wires of section 48, that what are the dimensions provided under this stipulated section. It provides the processing of conversion of unlimited company into a limited company. So now we'll look into this detail, that whose approval is required for the conversion. Subsection 1 of section 48 provides that the prior approval of the commission is required for the conversion of unlimited company into a limited company in writing. So no company can be converted from unlimited to unlimited unless the prior approval is given by the commission in writing. So this thing is expressly provided in under subsection 1. Now we need to move towards the next part of subsection 1, that what company need to do once the approval is granted, that what is the functionary, what are the functions of the company. A special resolution need to be passed by unlimited company amending its memorandum and article in a way that they include all the provisions relating to the company limited by shares. So it is evident from the second half of subsection 1 that the responsibility of the members of the company is to the extent of the inclusion of the provisions relating to the company limited by shares. Once these things are included, then what would happen? The unlimited company may be converted into a limited company, unless or until any contravention to the provisions of this section is committed by the members of the company. So now we move towards subsection 2. That subsection 2 provides that the process of the conversion shall be subject to the satisfaction of the commission. So if the commission is not satisfied, then no unlimited company can be converted into a limited company. And after the satisfaction, the commission need to give the approval in writing, after examining the status quo, after examining the history of the company. Now we move towards subsection 3, that where copy of the order need to be forwarded. Once the commission is satisfied, in the light of which the commission passes the order, then after passing of the order, where the copy of the order need to be forwarded. So under this scenario, subsection 3 provides the direction to the members of the company that after the order is passed, then the copy of the order need to be forwarded to the company and the registrar within 7 days from the date of the order. So it doesn't cover all the aspects that the order is passed. More important thing is this: the passage of the order from the commission to the registrar and the company. And once this whole process is followed, then what are the consequential effects of it? Subsection 4 of section 48 provides that if the provisions of the company limited by share has been inserted under the memorandum and articles of the unlimited company, then the company ceases to be an unlimited company. So meaning thereby the status of the company is converted. And then what members of the company need to do? They need to file memorandum of association, articles of association, and special resolution after completion of this formally provided procedure. And subsection 5 provides that what are the consequences if any company stands in default to the express provisions of the law. It provides in case of default, the company and every officer of the company who is in default shall be liable to a penalty not exceeding of level 2 on standard scale. So the penal provision is also classified under section 48, which provides that in case if anybody stands in contravention to these stipulated provisions, then need to be awarded with a penalty not exceeding level 2 on the standard scale. So the whole scheme of section 48 classifies the processing from the time of approval till the time of the conversion of the status of the company. So dear fellows, I hope that you got to know the processing of the conversion, and these are the mandatory provisions which need to be followed by unlimited company. So keep in touch with me for fresh lectures as well, and my contact number is given, so you can call anytime for further discussion and consultation on these issues. Thank you very much. Stay blessed. Allah Hafiz.